It's not as if the material is being published in the New York Times where it assumes a patent of credibility. Now, are there sites that take advantage of Section 230 by refusing even to remove material that the author has been held liable for posting, even if they're ordered to try to get it removed? Yes. And I am currently helping Maria's client, Ripoff Report, resist just such an attempted injunction. I think that's the right construction of 230, but most sites don't resist when they get that order. The discretion that Section 230 gives them in most cases goes in the right direction. In the end, I think what really galls companies that are criticized by Ripoff Report is not so much the mere fact that they're on Ripoff Report, is that Ripoff Report SEOs its pages to ensure they're listing at the top of Google search results, just as they ensure that when companies pay for the corporate advocacy program, it's only praise that gets seen on the Google search results. But you can get Google to take a website out of its search results if you've gotten a valid judgment against the content on the page. So there is a solution even for those hosts that resist. Now, my friend Eric has blogged recently about the problems with Google's approach. I share some of his concerns, but it is part of the solution to the problem.
Paul, when do we get to be the fun part?
I thought we already had. Go ahead.
So I do think we owe Gavin some thanks because it turns out it's not so easy to get people to take a full-throated attack on 230. And I don't even know if you got there, but many people, as Paul indicated, aren't willing to take on the statute. But I want to point out three things about your talk. So I'm not intending to beat up on you, but I'm going to kind of beat up on you. It was interesting you started out about giving the goal, that your goal was the freedom of expression. You started your talk and that was the goal. And I don't know what the rest of you think about that. That struck me as a really odd way of framing the goal. I look at freedom of expression personally as an input, not an output. That we care about freedom of expression because it does other things that we care about as part of the whole system of getting to where we want to go, as opposed to the end of the process. And so I thought that was an interesting goal. At least in my world, I'm much more interested in how freedom of expression then translates into some other social values that we care about. I think one of the debates we've had, and at this conference for the last 15 plus years, is it is true, and I think irrefutable, that there are a variety of intermediaries in the internet ecosystem who can control content that's delivered to consumers. Certainly the hosting service, if there's something in there for that position, then as Paul indicated, you work upstream from there. And all those people have the technological capacity to control whether or not consumers see them. I think the better question is, knowing that there's the technological capacity, when do we want them to exercise it? And we need to be careful when we put incentives on their docket for exercising that power because of the fact that they may have different incentives than we might want from society, in terms of social interest generally. And I think it would be easy to ignore the benefit of having a procedural out for cases that should lose anyway. And so to the extent that we conclude that in many cases there are unmeritorious cases in the system, I think there's enormous value to find a way to end those cases early. Not only because they don't tie up the court system, but because the person who is being the subject of this litigation trying to defend the content will have a much easier way of justifying doing so. And so one of the things I think is most brilliant about 230 is that it has enabled early outs in cases that probably should have lost anyway, but we find out earlier.
I know we need to take questions. Just two quick comments to Gavin's approach. The first approach is that, like the DMCA type of notice approach, and I think that the only real problem with that approach is that the author doesn't have the financial wherewithal or the desire to defend it. And so you won't, unlike the copyright world, you simply will not, and I've experienced this firsthand, you simply will not get the author doing the counter notification because they're not going to take that risk. And your second proposal or a possible proposal is letting the court decide it, and once the court has decided that it's unlawful, and then it should be taken down. The problem with that is that, once again, you've got authors who are going to default. So So we have that situation, and we've had that, in fact, that's the situation that Paul alluded to, where, and we've had it more than once, where there's a court action and people say, well, why doesn't your client take it down even when the court has determined that it's defamatory? Well, in both of those instances so far, it has been in the face of no opposition from the other side. In one case, the other side simply never showed up. When I say the other side, I mean the author. In one case, the author simply never showed up. They were completely in default. In the other case, they showed up and they immediately rolled over because they couldn't afford, no one wanted to defend the lawsuit. And so they stipulated to the injunction because of financial issues, not because they didn't believe that what they wrote was true. And so that's my biggest issue with your proposal. I think your proposal has some merit, but I think when we practically try to implement it, we learn that nobody's really willing to defend the free speech, even when it's true, even when it's helpful to the consumer. You know, who's going to step up to the plate and defend it financially? I think that's the problem.
I agree that cost is an issue, and that's certainly something that is a part of the overall picture of libel reform in England at the minute. And the big proposal has been kicked around, although the government haven't fully lifted it and run with it yet, the idea of establishing some form of tribunal or separate body that can make these decisions at a very early stage. That's where that comes from, the idea of minimising costs. But certainly, I mean, I acknowledge that that's long been a problem in English libel law, much more broadly than this particular area. I don't know whether it's worth mentioning or not, given I seem to be in the position of defending the right of big bad bully people to come and bring libel suits. I was in a position to launch a libel suit about 6 years ago against an ex-girlfriend who said a number of incredibly nasty things about me across the web, including that I was denied anorexic. And I looked at this and I chose not to because it seemed at the time that really it wasn't worth giving her that attention. I just threw that in a small bit for sympathy. I usually don't pictures of kittens, but...
Gets back to what Eric said. The people who protest the most loudly about what's posted about them are the ones that really, for the most part, really have something to hide and where it's hit too close to home. I think it's easy to ignore the lies. It's hard to ignore the truth, and I think that's what we've experienced. But I know you've got a bunch of questions.
There you go, folks. Questions?
Hi, I'm Adam here with the Mercatus Center. At the previous panel in here, Peter Swire made an interesting observation that there's this ongoing tension you see even within this conference about privacy and free speech that often comes up. And you clearly see that with a lot of things related to 230, especially on the defamation front or reputational issues. And I'm wondering if you could comment on some of the specific proposals that are out there today on both sides of the Atlantic. I'll just throw out one, the right to be forgotten and eraser button idea, which is percolating out there and seeming to attract a lot of attention and even support, including from the people in the book that you mentioned, Mr. The Offensive Internet book. So is that the beginning of a carve-out to 230, a privacy or reputational related carve-out along the lines of what we see for IP? Will we end up treating privacy and reputation differently than other things, and then what are the problems with that?
Personally, I don't think the pro-reputation lobby is nearly as strong in Washington as the anti-bullying lobby. I just don't see it happening. I think on the right to forget, you have to counterpose. You know, somebody wants their previous misconduct to be forgotten, and somebody else wants to talk about it. And I think here the First Amendment would triumph. You know, there is, there are rights of privacy that can sometimes surmount free speech, but they ought to be few and far between. Is it the right of somebody who's a public figure versus just an individual? But I worry about the abuse of the right to forget. I'm sure Bill Clinton would like us all to have to forget his conduct, which either was or was not sex with Monica Lewinsky. But I don't think he should ever be allowed to forget it. If there are still people who want to talk about it. He's a public figure. We ought to be able to remember it.
Hi, I'm Laura Ballard with the State Department. I was very intrigued with a case a couple years ago in Italy involving Google Video. There was a group of students who filmed themselves bullying an autistic classmate and then uploaded this video to Google Video where it sat for a couple of months and then somebody blogged about it. And what happened was, in the video, the students made some snide remarks about people with Down syndrome, even though the student was autistic. This then caused a Down syndrome advocacy group to bring criminal charges based on defamation. These were then brought against various Google CEOs and Peter Fleischer, the Privacy Council. And then privacy charges were added later. And what was interesting about the case is that the e-commerce directive was part of that. And there was some discussion in the case about whether Google should be immune from liability and whether it was a so-called pure hosting service, or whether there was something that they manipulated or made money off of this video in some way, or it was part of a money-making enterprise, so that it would be more analogous to, say, the publisher, and you use your example, and less analogous to, say, the printer or the newsboy or something like that, where I think Google was trying to present itself as a pure hosting service. So I just want to hear, all of your thoughts on that, and whether, particularly in light of the e-commerce directive, whether you think this is a good result, or is this a good approach to take, or?
Well, I mean, that's the one that it's been a bone of contention, and I think it inevitably will have to be part of the review of the e-commerce directive that the European Parliament, I understand, is in the process of beginning at the minute. The nature of a service provider has changed enormously in the last 10, 15 years. And what we had back then when they said, here's the internet, go, or here's some space put aside on it, we've now got people in that position who do an awful lot more and provide an awful lot more in the way of services. And certainly that the case, I don't remember exactly all the details, but I remember the case you referred to, and that came down to certainly the privacy front. The Italian law allowed them to bring a case under the article, it came under the Article 14.3 exception for national variation, something along those lines. But where we've had a difficulty in recent years has been eBay. Over the last couple of years, a French court, in relation to trademark infringement, it was of people selling counterfeit Tiffany and Rolex and all sorts. A French court decided that eBay were not a service provider and therefore not entitled to the Article 14 exemption. A Belgian court, in materially similar circumstances, based on, ironically enough, a report written by French academics, decided that eBay were a service provider and were entitled to it. In the UK, they've said, look, we can't issue blanket orders to say you must stop all infringement of Rolex. Where in Germany, again, on the Article 14.3 exemption, they said, okay, you weren't liable for hosting this because you weren't aware, but from now until doomsday, you must stop people from selling counterfeit Rolexes. You've now got this injunction, now this has happened once. So that, I mean, there is a distinct issue there about harmonisation, and that is a distinct problem. And it seems to me that a big part of the problem is that the role of the service provider or the intermediary has changed so much, with so many more services and things available. With eBay, with their, what the French court objected to, eBay offering feedback service and mediation, and they said, look, that's an active role. So that does need clarification.